Hi, my name is Mark Troutman. I'm an attorney with the law firm of Isaac Brandt, Ledman, and Teeter, and this is another video blog in my series on public records law. Today's topic is going to cover what you should do with frequent public records requesters. The answer? Provide them the records they request as long as they pay the reasonable costs and meet any other statutory requirements. Now, the topic of reasonable costs is often debated. What that actually means. Reasonable copy cost means exactly that, what it costs for your public office to be able to make a copy or produce whatever the item the person's looking for is to them. It does not include employee time. It might include mailing costs. Those seem like a fair thing and are actually contemplated under the statutes. And lastly, very likely does not include any costs if the person merely wants to inspect the records. Now, moving on, what other things should you be thinking about with frequent public records requesters? First of all, you can't limit the amount of requests unless you have some reason to believe they're making them for a commercial purpose. What you can do is simply, if someone is making lots of requests to you and they seem like they'd be for a commercial purpose, you can actually ask for a person to certify that they're not using them for any kind of commercial purpose. If they are using them for a commercial purpose, you can limit them to 10 requests per month. Now, the other thing that public offices often face with frequent public records requesters is that they don't know exactly what they're looking for. The changes to the law in 2007 actually require a public office to work with the person to help them figure out what they might be looking for. Now, the easiest way to achieve this at the beginning is to hand them a copy of your records retention schedule. This records retention schedule, as we've covered in other blogs, sort of serves as a menu of the items that you would have for them. They can simply go down a list, they know how long you've retained the items, and then they know how to ask for them. If they still are a little vague or a little overly broad, the public office still has a duty to cite the applicable law on why they're vague or overly broad and help them find out what they're looking for. Now, there's other specific rules when you start to ask why someone's looking for something or ask them to put their request in writing that we ask that you look at. But that will be a topic for another blog. If you have any other questions, please do not hesitate to contact me. Again, my name is Mark Troutman, and my phone number is 614-221-2121. Thank you.